Good morning to you all, or afternoon, or whatever. I got a little bit of a cold, so if I sound, I don't think it's a cold, I think it's an allergy. But if I sound a little nasally today, I apologize, but that's how I sound. Hope everybody is doing fantastic out there. Greetings, good morning to me. It's morning. What am I going to do today? Going to go through the most recent filings, and that's what we're going to do. And I'll bring you up to speed as to what's going on, to the extent that I know what's going on, and that's what we're gonna do today. Before I start that very interesting stuff, I wanted to go over, since we've did this before and continue doing this using Claude Anthropic for the most important purpose that AI should be used for is finding jokes or improving, really teaching Claude about jokes. So we're going to go through some. I'm not going to read them all because I thought most of them sucked, but some were marginally funny, and those, at least I thought they were marginally funny. And we'll go through that. So first we're going to do those, and then we'll go through the stuff. So for my what I asked Claude to do, and this was 5.0, extremely short but funny jokes about nasty lawyers. I'm not gonna. It gave me like 5 or 6. Most of them were terrible. I'm giving you the best. This again, Claude. What I would have to complain, Claude's sense of humor needs to be improved. That's obvious, but we get to kind of see how it works from week to week. So here it goes. What's the difference between a lawyer and a catfish? One's bottom feeding scum. One's a bottom feeding scum sucker. The other's a fish. And the other one that I'm of that group of like 6 jokes. Why did New Jersey get all the toxic waste dumps and California all the lawyers? New Jersey got the first pick. All right. Thought those were marginally decent. And then I told Claude, do better than that with 5 more with more bite. So it gave me 5, and let's go over those. A lawyer found a genie who offered him one wish. I want to live forever. I can't grant him immortality, said the genie. Fine, said the lawyer. I want to live until my client pays his bill in full. You sneaky bastard, said the genie. That was funny, supposedly. What's the difference between a nasty lawyer and a vulture? The vulture waits until you're dead to pick you clean and has never billed you for the circling. And I have heard of lawyers before billing more than 24 hours in a day on an airplane, so I understand the point there. A lawyer dies and complains to St. Peter, why am I here? I was only 47. St. Peter checks the ledger. Not according to your billable hours, you're 119. Why do nasty lawyers make terrible organ donors? Nobody wants a heart with that little mileage on it. And last on this set, the scientists switched from lab rats to lawyers for 3 reasons. 1, there are more of them. 2, the lab techs don't get attached. And 3, there are some things that even rats won't do. And last but not least, I said to Claude, those were good, but even 5 more that are super funny and more pun-like and biting. And I'm read 4 of those. What's a nasty lawyer's favorite yoga pose? The distort. Lawyers make the best fishermen. No one else can lie and bait at the same time. What do lawyers wear to court? Lawsuits pre-stained with the blood of prior clients. And last but not least, and a bonus also from Claude, the nasty lawyer's motto: where there's a will, there's a fee. Where there's no will, there's a bigger fee. All right. I thought those were reasonable by Claude, and hopefully Claude will be doing better next time. So kind of what I wanted to do, and good morning to all you out there. I see you lined up in the comment section. good morning. And I see others that I can't tell their names, but greetings. Two things that has happened that I've noticed since the last video I did. And just a reminder, we have a new judge, Judge Hardy. His first hearing will be August 6th, not his first hearing in the court, but the first hearing on this case will be August 6th. That'll be a status conference talking about the audit. There will also be a hearing, I believe it's on the 13th of August also, and that's a good faith settlement motion involving Mr. Benintendo that's pending with the court. So those, and there were some filings associated with that. Motion hearing date was set on that. There was a representation that the settlement with Mr. Benintendo, I guess, is appropriate and whatever. So this is what I did, kind of my thinking. And I'll kind of go through it and kind of give you like a little footnote as we go through it. It's kind of long. Two things. One, I filed an opposition to the good faith settlement with Mr. Benintendo, and I'll tell you my logic behind that and see what the court's position is on that. And two, I filed a brief about the upcoming status conference that's set for August 16th, just to kind of lay out to new judge, new court. They haven't been involved. So I kind of wanted to bring my idea was to kind of bring the court up to speed as to what the major issues are, and just so they could, so the file wouldn't be so overwhelming, and that the judge wouldn't be lost getting, involved in a case that's 2 years old. Literally, this case was filed 2 years ago. The receivership started September 18th of 2024, but the case was filed, I believe, in June of 2024. So we've been going for quite some time. There's a lot of stuff for somebody to kind of learn it all. It's tough. So I kind of tried to put it together so the judge can kind of catch up and also obviously communicate what I thought were important issues. So first, with regard to the good faith settlement motion, I don't really have any opposition with the motion other than the audit is not done. So to the extent that these are settlements involving prior management, but we still don't know what the financials look like. And at one of the prior hearings, as I've spoken about, the receiver mentioned there were hundreds, if not, I think it's like 1,500 to 1,800. I don't remember the precise number. It was over 1,000. It was less than 2,000. I think it's somewhere between 1,500 and 1,800 transactions that they didn't have backup for. And that's one of the reasons, at least at that point in time, this is when Barton CPA was still on board. And I'll go through the history because I do the history anyway. But Barton was the CPA who quit, hadn't completed the job, quit sometime March, April of this year. But anyway, that's when they were involved. So they raised the issue that there were hundreds, if not thousands, of transactions that they couldn't account for, and because of that, they couldn't finish the financials. That was the pitch that was made. Now, I don't know if that was true and accurate, since they quit, since a lot of us are somewhat skeptical of some of the information we've received about the audit, and I think appropriately so. But that's what they said. So with taking the receiver at face value that there's all these transactions that are unsettled and there's no backing and you can't complete the audit, then we shouldn't be settling with parties that the receiver claimed in his receivership reports engage in all kinds of misconduct, according to him. So why would you settle with a party without knowing fully what the financial state, why would you do that? Especially with the larger parties that still are outstanding, like Reichman, his daughter, I think are the biggest ones. But I don't know why you would settle until you had an audit to make sure that you knew what you were settling, because perhaps the person was in a different position than you thought they were, and there's no reason not to do that. So as a rule, from this point in time, I'm going to be opposing any settlement until there is a audit done, because I don't think it's possible to understand what the financials are. And if you can't understand the financials, you shouldn't be making a decision about settling out. I'm sure they're not happy about that, as many other things they wouldn't be happy about. But I'm not happy that we're 2 years into this and we still don't have an audit, let alone, not only do we not have an audit, we don't have an agreement at this point in time with any auditor that I've seen, signed engagement, even though the receiver talked about it at length multiple times. Didn't make a lot of sense, by the way, in my opinion, which all this is just my opinion here, sitting out here, not legal advice, of course. So I objected to the good faith settlement. That's a hearing on the 13th. I'm sure there'll be a response that will try to, justify that, but it is what it is. So that's it. What I additionally did is I filed, as I indicated, I filed a somewhat lengthy, and I'll try to read it, at least in part, just so you get the kind of flavor for it. And this is what I filed with the court. And again, the idea was to bring the court, the new judge, up to speed as to where we are and what the issues are and what our concerns are and all that other stuff. To the honorable court and to all parties in their record of counsel, Richard Hoffman, I'm filing it as a declaration. I have all this information. I'm kind of paraphrasing now, so I don't bore you to death. I own a bunch of shares. Now I'm going to read a little bit. During the course of the receivership, I've offered many concerns directly to the receivership with regard to the handling of the audit and other material issues. Up until the time that Barton CPA quit, now several months ago, without any demonstrated replacement as of today, many of my accurately and publicly disclosed concerns were ignored, which I'm sure is not well received by the receiver. That was my comment there. This has left shareholders in a more vulnerable position, especially since there is almost no cash left in the estate per the receiver. And if you recall, the receiver said a couple of hearings ago that there was less than 10,000 cash left. He was asked about the audit. He suggested or implied or I inferred that he was going to borrow money or could borrow money or had a source of other money. I don't know if that money, those funds they were planning to settle with Reichman, but they didn't, apparently, and didn't ask for an extension, and there's no motion pending on that. And I don't know if there's other activities along those lines. I'm sure there were, I know for a fact that in 2024, there were SEC complaints that were filed and received. I don't know if they've been acted upon, but I know they were filed. And who knows what happens with those SEC complaints? Who knows how much of a tail there is on those? So at some point in time that the SEC will actually act on it. It's very possible, but they haven't. But I know for a fact that there were SEC complaints that were filed with regard to GTII as of, I know, May of 2024. So that's over 2 years ago, without an acknowledged receipt, but no response. So anyway, I'll move on. I only represent myself in this matter. However, I'm in contact with, and by the way, I try to be accurate. Let me get a tissue for a second. I try to be accurate. If I'm not, please, comment, suggest, whatever, clarify, have somebody else submit something. But I try to be accurate, so I try to be conservative in whatever I state. So a lot of times if I say something, I actually mean something even more than that, but I don't want to overstate something because, you never know. So I only represent myself in the matter. How I'm in contact with many shareholders of GTI through social media and a YouTube channel, and have ascertained that many shareholders are even more dissatisfied with the receivership's performance than I am. I'm specifically focused on the audit and getting a transaction done because that is what will benefit retail shareholders. There appears to be general mistrust and concerns as to the handling of the audit, an issue which Judge Williams recognized as essential for the shareholders from the very start of the receivership, as well as concerns regarding completing an additive corporate transaction. To date, the receivership has seemingly zapped all the remaining liquidity out of GTII without completing the tasks needed to assist retail shareholders. And so let me stop right there. So what I meant by that was there was cash in, and again, I'm not complaining about this. I'm just putting it out as fact. There was money in the estate. Money has been used to pay legal professionals, I guess auditors, perhaps the receiver's expert, forensic accountant, the lawyers in Texas, any other lawyers. They haven't paid me though. Any other lawyers? So there was a bunch of money that was expended. They brought in some other money because the receiver got paid 10% of the monies they brought in. I think he's been paid, somewhere between $150,000 and $200,000, which would mean perhaps another $1.5 million in the account. About 60 days ago, the receiver indicated there was less than $10,000 in the account. So all the monies have been expended. At some point in time, I'm sure we'll get an accounting of all the monies that are been expended, but that's kind of the rationale. Continuing on, the receiver has done a good job obtaining some cash already spent and repatriating questionably distributed shares. However, without a fully completed audit and additive transaction, then this is in parentheses, the receiver's obligation and duty undelivered since September 18th, 2024, any positive accomplishments by the receiver are meaningless at best to retail shareholders. Then in parentheses, the 15,000 or so who are supposed to be the actual beneficiaries of the receivership. 3, in late 2023 or very early 2024, I decided to try and be helpful to retail shareholders in GTII after my experience in a stock with a ticker labeled MMTLP. MMTLP is a stock that years later still has not settled, now also referred to as NextBridge Hydrocarbons. I had a minimal investment in MMTLP, so losing my money was not devastating. However, to some who had invested their life savings, it was traumatic and sometimes life-ending. I not only tried to help, but felt empathy for those harmed by the shenanigans undertaken in the financial markets. Part of the MMTLP transaction for some included an expectation of liquidity arising out of short positions. And I guess to some of you who weren't involved with or the ongoing MMTLP saga, where I think I just saw a recent posting by Greg McCabe saying that they've reached out to the SEC on 6 occasions, or this was the 6th occasion they've reached out with regard to a particular issue, but they have not heard back, which is kind of consistent with the way I started this, or just mentioned that the SEC has received complaints. I know of one at least from May of 2024 that was acknowledged received, and they've done diddly squat, or at least they haven't communicated that they've done anything to the complainant. And I checked on that as of this morning before I made that statement. So I'm going back to this. However, to some who had invested their life savings, it was traumatic and sometimes life-ending, referring to MMTLP. I not only tried to help, but felt empathy for those harmed by the shenanigans undertaken in the financial markets. Part of the MMTLP transaction, for some including an expectation of liquidity arising out of short positions. 4, separate and apart from my general desire to help retail investors as time progressed in late 2024, and this is personal, which I kind of indicated to everyone recently, just so because otherwise you wouldn't have known it and it wouldn't have done what I wanted to demonstrate. Separate and apart from my general desire to help retail investors as time progressed in late 2024 and sensing an unwelcoming haze arising over the country, and based on my disclosed Jewish and Holocaust background, and without disclosing the motivation until recently after visiting the Auschwitz concentration camp from where my mother miraculously survived, I elected to quietly dispel tropes about Jews by spending my personal time and money without charge or notice in the sole interest of others, being all GTII shareholders. This became and is still my compelling reason that drives me to try and help GTII retail shareholders, and that is absolutely true and correct. 5, a large number of GTII shareholders involved today were also MMTLP shareholders. Many of them became involved in GTII after hearing positive information about potential GTII transactions on social media. Moreover, many were also supplied information about positive financial ramifications that could arise from the purported short position involving Alpine Securities that had been confirmed by the DTCCCC in administrative proceedings against Alpine. And just stopping and making a little comment, that's also what happened in MMTLP. There was information, or people were supplied information about positive ramifications that were going to arise because of the status of MMTLP, and because it was basically stopped trading and nobody got a chance to close out the transactions, nobody got to benefit, or most people didn't benefit from the positive financial ramifications. So there's a similarity between the two, and probably that's why also that I was compelled by the situation with GTII, because it did remind me of that. And there were people probably in good faith who were representing all things about GTII to investors. I'm sure they were well intended, but the information obviously was not accurate in light of where GTII is today. 5B. Alpine has been the subject of many proceedings by the DTCC, SEC, etc. The remedy sought by those agencies after many asserted violations and interim and final penalties is now in the essence the complete cessation of Alpine's business, although Alpine is still currently in business. Although my communication to the receiver's representatives regarding Alpine were ignored or minimized when I presented it to them. So here I'm claiming I've represented and suggested many things to the receiver. I would say most have been ignored. Most I was correct. Some of the strategies they have undertaken I didn't understand and I disagree with. People can disagree on strategy, but I didn't understand it. And I would have done things differently, and I'll give you an example when we get to that. Although my communications to the receiver's representatives regarding Alpine were ignored or minimized when I presented it to them, apparently recently and nearly 2 years later, they have appropriately seen the light on that issue too. Somehow, after discovering that someone affiliated with GTII's senior management in or about September 2022 turned approximately $60,000 into nearly $11 million in approximately 2 weeks, apparently involving Alpine, and per the receiver, GTII management linked long accounts held at Alpine. The receiver is now seemingly pursuing discovery in that area, my comment, at a less than feverish pace, perhaps due to outstanding receivables. So my comment there is, the Receivers Council has kind of moved at different paces under, and I don't know, I've never been a party to what their specific strategy is, and maybe there's a specific strategy that governs what they have done. But at certain times, they've kind of moved very quickly, and as I kind of described it, in a feverish way. And at other times, kind of like they seem to be stalled in a way. As to the Alpine stuff, they don't seem to be moving as fast as they've moved on other stuff. Maybe it's an correct perception, very possible, but that is my perceptions. That's why I commented on that as such. 6, after investing in GTII in or about the fall of 2023, I started hearing murmurs of dissatisfaction in the management of GTII. Should have said about the management of GTII. There seemed to be a buzz that senior management was trying to not engage in legitimate corporate enhancing transactions, and the ambiguous financial status of the entity inadvertently came into play. I think that came into play, by the way, more so when Borgers, the CPA, got terminated by the SEC, but we haven't got there yet. The finances did not make sense, especially for a company that produced virtually no revenue. It appeared that GTI's main business was to be an incubator that almost completed many transactions, but actually closed none. As the stock price had varied dramatically over the years, it was also obvious that someone had benefited greatly in trading the stock of a company that never really did anything. Especially in light of the absence of any audit or needed SEC filings, it would now appear imprudent to enter into any further settlements with prior management that the receiver has identified as main culprits. And just to kind of another as a side comment, I went to Claude and I had Claude look up and give me an estimate of the number of SEC filings or OTC filings that were due now. And it gave me nine. They said as of today, there were nine filings that needed to be made. This is more than, for example, when the receivership started. So we've grown in that. It also said, and again, it couldn't find it, and I don't know if it's correct, but it also said that when the change was made from, I think, Fortune CPA to Barton CPA, that there needed to be a filing at that time that was not done. So that would make it 10. And per the order of the court, and I'll just read it to you so we can be on the same page. So this was if I find it, because I had it right in front of me. This is the order appointing the receiver. It's dated September 18th, 2024. I go to page 7, paragraph 21. It's a long doc. It's 20-page order, so it's long. But I picked out paragraph 21 because I thought it was most of interest to at least my discussion here. 21. I'm just reading the order of the court. This is what's signed by the court. Finally, the court further finds that the receiver requested by plaintiffs, that was the plaintiffs group that was represented by other counsel. I am not represented by them because I'm in pro se, representing myself. So let me read it again before I interrupt myself. Finally, the court further finds that the receiver requested by plaintiffs, Paul L. Strickland, is competent and well situated to serve as equity receiver of GTII. The court notes that Mr. Strickland is ready and prepared to take immediate. So let me just read this again. Order of the court, September 18th, 2024. So approximately 2 years ago. The court notes that Mr. Strickland is ready and prepared to take immediate corrective action with respect to GTII's delinquent OTC and SEC filings. So I'm just going to leave it there. So immediate, I believe, would suggest a period of time less than 2 years, substantially less than 2 years. It also would suggest that there had to be some contract with somebody to do the work. So when I see that and we're 2 years in, that I find very disturbing. So that exhibit will be before the court. It's filed as an attachment to the brief I'm reading, and there's 2 other documents that I'll refer to in a second. So the finances did not make sense, especially for a company that produced virtually no revenue. It appeared that GTI's main business was to be an incubator that almost completed many transactions, but actually closed none. As the stock price had varied dramatically over the years, it was obvious that someone had benefited greatly in trading the stock of a company that never really did anything. And then I mentioned the thing about the filings. There have been no filings. And again, Claude says the number of no filings would be 10, 9 periodic reports, plus there should have been a transactional report, according to Claude, when there was a shift away from Fortune CPA, which came in after Borgers. There should have been a filing bringing in them. Okay, but I don't know if that's true. I don't know if they did the filing and Claude just couldn't find it or whatever, but that's kind of the way it goes. And since the order seems to suggest they have to take immediate corrective action, and since there appears to be an inordinate number of reports that still haven't been done, seems like that the receiver has not met the burden or challenges that the order puts on him to that. Per the receiver, now I'm reading it. 7. Per the receiver and stated by him in open court at one of the hearings in either late 2025 or early 26, and without disclosing any transactions, the receiver indicated there were many hundreds, he might have said close to 2,000 but less, of transactions that did not have proper backing or support that were then purportedly holding up completion of the audit. Months later, of course, Barton CPA quit without any final work product. As the auditor and those transactions have not been disclosed or provided, and since they could involve or impact a party who's trying to settle out with the receivership, absent the completed audit and filing, no further settlements should be permitted. We do not have enough information to make a deal with anyone else, and this has become more of a problem as believable excuses for not completing the audit and regular filings have all but disappeared. I think it's kind of self-evident. 8, pre-receivership in late 2023 and then often through late spring 24, I communicated with and attempted to communicate with representatives of GTII about what was going on at the company, what the status of the financials were, status of any pending transactions, status of needed filings of required SEC filings, then parentheses, the filings and regulatory filings are still an issue that has not been handled by the current receiver. Now I'm going to back up and just give you a little filler information. I mentioned MMTLP and I was involved with that. What I ended up doing is I was involved in a FINRA controlled arbitration, discovered the failures of the FINRA controlled arbitration, but I was trying to find out, get discovery as to the MMTLP situation, took it up to trial. Our judge, in my opinion, was terrible. And I found out afterwards why I think he was terrible, but he was terrible. And we bailed at the very last minute so we wouldn't get a negative result that might bind every shareholder against us. I didn't have any expectations at that point in time of prevailing in light of the way the proceedings were handled. The receivership gave no discovery, etc. There's a record. You could watch a bunch of videos on it because I went through the arbitration kind of per hearing and per filing, kind of as I'm doing here today. But anyway, that's kind of what I did there also. Unfortunately, JR did not pay me for that either. So I'm continuing on. 8, pre-receivership in late 2023. I read that. So 9, in 2024, I questioned what prior management was doing, etc. Because of my investigation, and I'm not trying to boast here, by the way. I'm just trying to put it in context of what went on, and also to establish that I've been involved and have personal knowledge of a lot that has gone involved from the start of the filing of the case all the way through, so that the judge will consider this will consider me with more credibility. In 2024, I questioned what prior management was doing. Because of my investigation and lack of acceptable responses from management, which I communicated publicly to shareholders, a plaintiffs group was formed and a receivership was born. I feel that without, and again, I'm not trying to boast, just trying to put it in character, in context for the judge. I feel that without my investigation and work that the company would have folded, and the principles that the receiver identifies in his reports as being engaged in misconduct and misappropriations would have continued their wrongful actions while retaining what, according to the receiver's seeming suggestions, amounts to tens of millions of dollars of value. And I'm basing that upon what the receiver says. And again, just the position is, if we kind of let this go, and it may end up going that way too, despite our efforts. But if we kind of let it go, there would have been a bunch of people that would kind of probably kept a lot of spoils that maybe they shouldn't have kept. And perhaps by intervening, at least, if nothing else, we've kept that, we've kind of intervened and maybe denied some people money. And we certainly made it life more difficult for those that needed life to be more difficult for, not shareholders. 10, as a side benefit of trying to assist retail shareholders, prior management, this is a joke, by the way, or this was I'm making a joke, but this is what happened. As a side benefit of trying to assist retail shareholders, prior management sued me personally for defamation. Although the allegations against me had no merit, parentheses, as to Mr. Reichman, for example, according to the receiver's reports, his acts were far worse than anything I suggested happen. The actual truth was far worse and extensive than any theories that I opined about. That means gave an opinion about. However, before the action was dismissed, pending Rule 11 motion at the time and slap motion in play, I had to invest more time and money because of my attempts to help. 11, I did work closely with counsel that had the receivership established, not the current receivers counsel. So that would have been Alex Calloway. So he represented the plaintiffs group. I think theoretically they still represent the plaintiffs group, but they haven't, they aren't really doing anything at this point in time. For example, the last hearing, I think the only parties that spoke were the attorneys, one of the attorneys for the receiver and myself. I don't think anybody else spoke, including the plaintiff's attorney. I went in pro se, and that's kind of one of the reasons I went pro se. So I did work closely with the counsel that had the receivership established, not the current receiver's counsel. I helped him with a note. I helped him with the paperwork, declarations, whatever, reviewed the documents, commented, signed the declaration, etc. So I spent a bunch of time and was involved with that. However, I did not select the receiver, nor did I know his receivership background, style, or personality. I did not negotiate any payment agreement entered into with regard to any receivership, nor did counsel that sought the receivership seek approval of the plaintiff group. It represented the payment group. The court note: the court did not state that they couldn't enter into a payment arrangement without consulting with the plaintiffs group. I just think it would have been a better idea if that was done, so everybody could sign off. Perhaps it wouldn't have changed anything, but it is what it is. It is my recollection that as of the time the receivership was initiated, approximately $1 million plus or minus in cash was in the corporate coffers, and that since then, approximately $1 to $2 million have been brought in. But per the receiver, a couple of hearings ago, probably April or May 26, less than $10,000 remains. And again, that statement is a note. That statement was made in open court, and it was made either at the time that the hearing was with regard to Barton CPA and why they were quitting, or it was one hearing before or after. But it was clearly made, or at least I clearly heard, because it was with regard. It was with regard to, sorry about that. It was with regard to something else. But it was $10,000. It was clearly the receiver was asked about the current audit. Can he get a new auditor? This is post the Barton quitting. He mentioned we have less than 10 grand, but suggested somehow magically delicious, like Lucky Charms, that problem could be overcome. I don't know. He never described how that would be done. Excuse me for 1 second. He never described how that would be done, but he certainly intimated that the money could be raised to do the receivership. And that's kind of how it goes. So 12, although anything is possible in the future, to this point, any and all benefit. So I think this is an important point. And this is kind of the point I'm trying to make to the judge, because I believe, this is my commentary, not what I wrote. I believe that this receivership was set up not for the benefit of the receiver, for the professionals working for the receiver, but it was set up to try to benefit the retail shareholders. To this point in time, I do not see any benefit to retail shareholders based upon the current status of events. So this is what I'm trying to communicate in this paragraph. Although anything is possible in the future, to this point, any and all benefits from GTI receivership have come to only benefit of the receiver, the professionals working for the receiver, third parties, and not for shareholders. The only reason this particular receivership exists is to benefit shareholders. 2 years into the receivership, and the only group who has not benefited from the receivership are the shareholders. As the court September 2024 order appointing the receiver implies, per page 7, paragraph 20, without immediate regulatory compliance, the shareholders have nothing. I think I've made the point. 13, even though I made the point, I'm going to say it again. 13, said differently, although the receiver is recapturing more money, parentheses, that is now fully exhausted, and has a large sum of currently non-trading shares potentially canceled, none of that matters to retail shareholders holding the bag. As has been reiterated literally dozens of times, without an audit, parentheses, plus the increasing past due regulatory filings, and a real business contracting with or merging with Gtii, the stock will not trade and retail shareholders will get nothing. 14, the main reason for the receivership was not only an attempt to establish exit liquidity for buried shareholders, but to actually revive Gtii. To this point, not only has the receiver not completed the audit or regulatory requirements, but no additive transaction appears to be in the works, parentheses, and the receiver does not appear to be aggressively pursuing other deals, close parentheses. I've heard claims that the receiver might be simultaneously involved with other companies and perhaps doesn't have sufficient time or interest to what is needed for Gtii. Let me stop there. I don't know that to be a fact. I've heard that mentioned by other people, but I don't have personal knowledge of it, so I'm just referencing what others have kind of suggested. Now I'm back reading. Because I have tried to closely monitor the receiver's actions and been open about how I see the good and bad, from my limited interactions with the receiver and my more plentiful contacts with his counsel, I know they do not like me and probably resent having to account to shareholders. 15, and I believe that 100%, by the way. 15, the receiver's compensation agreement, parentheses, Judge Williams initially determined that the receiver was competent, but in my opinion, this could be the receiver's first receivership and/or he has very little experience with managing receiverships, which is certainly evident in his handling of the audit. I'll continue that sentence. Receiver's compensation agreement was that the receiver, in essence, would not charge an hourly, monthly, or capped fee, and based on performance, would get 10% of all monies recaptured and all of the shares repatriated. At the time of this announced agreement, because the management of Gtii had canceled about 35 million shares, most people, including myself, thought the possible outstanding amount of shares was closer to 35 million, not 175 million that existed. Parentheses, many potentially arising out of illegal short trades as referenced above. Let's take a brief break. I'm going to go over here to my right or your left, take a sip. We're going to shake out our hands, and now we're going to continue. We're almost halfway home. We are slightly more than halfway home. In one of my hearings, in my opinion, the receiver and his counsel have treated me as an adversary since the beginning of the receivership. And if you remember, I'm stopping. I had an interaction with the receiver's counsel, and they said they didn't trust me because I didn't have a monetary motive, which I found ridiculous and appalling, and raised a reasonable argument. 17, in about very early November 2025, I was informed by counsel for the receiver that the main counsel for the receiver had been paid approximately $500,000. I estimate they are currently owed at least said sum. I estimate based on the cash brought in that the receiver has been paid between $150,000 and $200,000 to date and in excess of 10 million shares of GTII. It appears that Barton was paid about $55,000. I do not know how much the receiver's forensic accountant has been paid, nor what value has been provided in light of the status of the audit process. Let me stop there. So part of the pitch that the receiver has made, that he's also had a forensic accountant on staff. I think it's been since the start. Forensic accountant who's an expert in accounting and finding stuff. So it strikes me as odd that we, myself, a bunch of other people, have been clamoring about the audit and various financial stuff and about the ongoing audit and requesting. I mean, I specifically requested that they contact the auditor and find out what's going on, that they have a hearing about the auditor, and they kind of poo-pooed that. But they had an expert on. So didn't the expert kind of sense, especially in light of all the changes? I even got to the changes about the auditors, but in light of the changes in all the auditors, didn't the expert kind of sense something? And because the original auditor, Borgers, got shut down by the SEC and they were apparently just making up stuff, if I were the receiver, then choosing an auditor, I would certainly be careful in that area based upon what had happened. Anyway, I don't know. I don't know what as all the money went to. I don't know where it's all been spent. We could use an accounting of that. I'm not saying there's anything untold about that, but we probably should get some kind of accounting, some transparency. I know the receiver talks about transparency. I think the receiver has been less than transparent. If you look at the site, the X site that was set up, I mean, there's very little commentary. In court, he's really close to the vest in terms of how he talks. Hasn't spoken to the shareholders. Hasn't been particularly friendly to myself. Maybe that's his personality. I don't know. Maybe it's nothing personal. But I don't think he's done a good job. Despite all the reports are kind of static. There's no way of interacting, asking questions. So that's my opinion. Again, 18, when Judge Williams approved the establishment of the receivership, he was clear to communicate that the interests of shareholders were paramount. Moreover, getting an audit done immediately was essential. 19, the audit. That's where we are. And so this is kind of, I'm trying to inform the court as to how the audit process has played out. Now I want you to put yourself in the position of the court and decide if you heard this, would you be concerned about the audit, and what would you do if you were the judge and you heard this? The audit. The main former principal of GTI, Mr. Reichman, apparently was a tax expert CPA who ran a high-end tax practice. He was a sophisticated expert. Hence, it is likely that any financial activities that occurred as to GTII were done with intent to disguise transactions, and that it was what the receiver's many reports suggest. And I put in parentheses, prepared with the assistance of counsel, close parentheses. As it turns out, in early 2024, I think it's the comment here, I think it was, the very February, March, somewhere around there of 2024, the auditor chosen by GTII's former principal, comment here, and that's because, again, I'm referencing that Mr. Reichman is a tax expert. The firm that he chose to do the auditing, Borgers, is the name of the firm. So the auditors chosen by GTI's former principal, Borgers, was the name of the auditor, was shut down by the SEC. So the SEC completely shut down Borgers. Apparently, Borgers had been undertaking work without analyzing any transactions, but by just changing dates and not doing actual work. For example, a 2021 fourth quarter income statement could become a 2023 income statement. Literally, there were allegations, and they're basically shut down. But there were allegations that they would literally just do that. They might just change the date on a document, and they had way too much work. They were making way too much money. They didn't have enough personnel or systems set up to do it. So these kind of made up documents. That was the firm that prior management chose to do the auditing. As a result, after the SEC literally just shut them down, closed them down, all companies audited by Borgers were required to be re-audited. So the reason, and this is when I said that we found out kind of inadvertently the financial status. This is one of the ways, because the prior auditor was shut down and all the companies had to do re-auditing. Now I know, and I mentioned MMTLP, NextBitch Hydrocarbons also use Borgers, but my understanding long ago, their audits were complete. Now maybe it's different kind of audits, whatever, but it's kind of surprising to me that, especially after Borgers is shut down, that a auditing firm couldn't be found to complete this transaction. I can't imagine that this is harder to audit than Tesla or any company. Again, no revenue, so we're just talking about transactions. So perhaps a decision has to be made on how certain transactions are considered, plus or minus. But it seems like you could find an accounting firm, certainly a large accounting firm, to do the work. Why that hasn't happened to date, I don't know. That's a question I have. Certainly was money available when the receivership started. If they wanted to go to a big accounting firm to get it done quickly, at least that's what I think. And there's been no communication, nothing disclosed that gave any reason for not doing that and why they chose the path they chose. 20. At or about the time that the receivership litigation began and after Borgers was extinguished in spring 2024, but before the receiver appointment, prior management hired a new auditor, Fortune CPA, to complete the audit. So the audits were required because of Borgers being kicked out. Borgers was the company picked by prior management. They chose Fortune. I think the timing is they charged Fortune after the lawsuits filed, which is maybe June. The receiver's not appointed until September. When the receiver's appointed, Fortune is in there. That's kind of the sequence of events. Fortune was the receiver picked by prior management to succeed Borgers, who had also prior management had succeeded. I remember at the time opposing that, saying, why would you stay with the prior management that you question their actions? But anyway, continuing on. Now I'm referring to Fortune CPA. They began their service prior to the 9/18/24 receivership order. I, and others probably did too, communicated to the receivership that keeping the auditor that prior management chose was a bad idea, especially when it was the receiver's position, obviously, that prior management, tax experts, had engaged in some level of shenanigans as to the finances and securities of GTI, according to the receiver. So it didn't make any sense to me at the time, today, future, why they would rely upon prior management's choice to do the audit. Maybe again, it was being penny foolish, trying to save money, not understanding the audit process. I don't know, but that's what they did. 21, as reflected in the order appointing the receiver dated September 18, 2024, nearly 2 full years ago, page 7 of 20 attaches Exhibit 1 hereto, and consistent with the judge's interest to protect and benefit shareholders, it demands immediate corrective action as an essential obligation of the receiver. Note that almost 2 years ago, the receiver agreed to take immediate corrective action regarding delinquent OTC and SEC filings, and obviously audits necessitated for same. Not only has no corrective action been communicated or apparently undertaken, but the number of delinquent SEC OTC filings, perhaps now 9 or more, is actually growing in opposite to the order. It's kind of like the facts as I know them. 22. Lo and behold, the auditor retained by prior management in 2024, Fortune CPA, and retained by the receivership did not work out, ended up in an adversarial relationship with the receivership, and despite the warnings offered by me and others, and after wasting months of precious time, the receivership terminated Fortune in very late 2024 or very early 2025. In early 2025, without any coherent explanation for the choice, the receivership then chose Barton CPA to undertake the audits. This turned out to be another bad choice, resulting in no work product and a waste of now exceeding 18 more months from when Barton started, and it's more than 18 months now. So my point and what I'm trying to communicate to the court there is they didn't tell us. So they chose they made a wrong decision. Excuse me. They made a wrong decision by keeping Fortune, which was obvious, and wasting time. And then they chose Barton, and they made no showing as to why they chose Barton. Obviously, the choice of Barton was the wrong choice for two reasons. One, they never completed any work product, and two, they quit. So that being the case, I'm going to say that was the wrong choice. Would also make, and I get into that in here, which also makes that choice odd of Barton, besides the fact, why didn't they go to a big accounting firm to do it in light of the fact they had a pile of money at that point in time? But why didn't they go to the Integrita firm that they represented, that they had a great relationship and did great work and had a great rapport that they were working with prior to the time they selected Barton? How do I know that? Because in open court, when they were talking, this is after Barton quit, there was a discussion about the firms that were potentially available to complete the work. Integrita, I think is the name of it, and Boca Raton was the one that the receiver pushed, and he indicated he had been working with them for over 2 years, which would predate Barton, and had a great relationship, and that's the firm he chose. But he didn't indicate why he had not chosen them back when he chose Barton, which, again, obviously a mistake. Didn't reference why he didn't choose a Big 8 accounting firm or a big accounting firm. Anyway, moving on. 23. What is curious about Barton's CPA is that when they unilaterally quit in 2026, not having completed the job in a court hearing necessitated by continuing audit issues, the receiver implied that as of the date he had chosen the Barton firm, that he had been doing business with, and loved working with another auditing firm in Boca Raton with a name like Integrita. I think that's how you pronounce it. Moreover, he said as of approximately April of 2026 that he had been and was working with the Boca Raton firm and had been for 2 years. He might have said more than 2 years. He said they were excellent, he got along with them, etc. He never had explained, however, why he had not chosen them instead of Barton in early 2025. You would also think that the receiver, knowing about the past history of Mr. Reichman and the history of Borgers, that someone doing a diligent job regarding the problematic audit issue would make sure to choose a firm that could not only undertake and completely complete a full job quickly, but also choose a competent entity that all shareholders could trust. I think that's how we all believe, if you know what I just said. 24. Note, at the time of hiring of Barton's CPA and earlier, the receiver had indicated that the audit would be done in 30 days, before the end of 24, soon, imminently, etc. Attached here too as Exhibits 2 are portions of the second and third interim reports, where in the audit portion, what was suggested would occur still has not, some 2 years later. At numerous hearings over the past 2 years, the receiver gave the indication and led everyone to believe that the audit would be done soon. It was almost done. It will be done imminently, but as of today, still not even a current engagement agreement with any auditor has been disclosed, let alone the required SEC filing noting such a hire. And I'm just going to briefly discuss what's referenced. And what I referenced, hopefully you can hear me, is the second interim report that was filed November 12th, 2024. Just keep in mind, receivers hired September 18th of 2024. So now we're 2 months later. And in the audit, and so Fortune would have been working on it. Fortune was the company that replaced Borgers, that was hired by prior management, that was retained by the receivership. And in the audit section, it says, and it's short, so I can read it. The receiver, and this is page 2 of 53 of that report, the receiver's second interim report, page 2 of 3. So it's important because it's right up front. Audit matters. The receiver continues to work on the audit. The current status is the auditor is reviewing audit open item support documents delivered to the auditor on November 8th, 2024. The receiver awaiting certain accounting treatment comments back from the auditor.
He anticipates completion of the audit by the end of November, taking in consideration holiday scheduling. So just to be clear, it's November 2024, not November of 2027 that the receiver is referring to. Obviously, as of November of 2024, there was no completion of anything, no audit, no nothing. So from there, and again, I just kind of used sampling. I didn't want to attach all the receiver's reports and the various information. Just kind of wanted to give a little color to the court about what was reflected in the reports. Receiver's third interim report, this one was filed January 14th. So this is about 4 months after the receivership started. And here it talks about audit matters, and attaches a letter in this report directly from the receiver, dated January 13th, the letter, and it refers to the audit matters. And I'm just going to read it because it's not too long, but it's interesting. Dated January 13th. So as of this time, Barton has already been hired. So we had Borgers chosen by prior management, shut down by the SEC. Fortune, hired by prior management, retained by the receivership, fired by the receivership. Barton, hired by the receivership, and after they are hired, in the third report, this is what the receiver is telling us about the audit. The receivers determined that the GTI's current auditor, this would be referring to Fortune, is unable to complete the audit within their budgetary guideline and is seeking $46,000 additional fees for work conducting during a period of time when no additional items had been delivered to the auditor. So he's basically saying they're trying to scam him. So the receiver that the prior management that the receiver claimed prior management had engaged in all kinds of shenanigans, here it appears to me the receiver is claiming that firm that they had retained was trying to extract monies that were not due and is not willing to provide a reasonable estimate of audit completion. The auditor has taken an adversary posture during these matters. So not only did they not complete it, but they became adversarial. Who would have guessed that the auditors hired by prior management that the receiver claimed were engaged in shenanigans, that auditing firm would end up being adversarial to the receivership? Shocking, even though the receivership was told and it was obvious, and all it did was waste time and money. Continuing on, receiver's accountant and is unwilling to share specific information critical to our understanding of how the audit can successfully be completed, or even provide us with ongoing communication and updates of their work. So they wouldn't cooperate. They wouldn't do according to the receiver, the guys they decided to keep basically said, get away from me. We're not going to help you. We're not going to give you any work product, etc. The auditor has also asked us to diverge from GAAP principles and conduct our own audit confirmation process with individuals and entities without disclosing to us the various parties that have already completed this confirmation process in defiance of PCAOB guidelines. We deem this behavior unacceptable, inappropriate, and highly unprofessional. Perhaps they should have known, my comments, perhaps they should have known that when the prior management hired them after Borgers. Last paragraph, and this is the part that we should be paying attention to. Again, this is January 2025. As of January 8th, 2025, GTII has retained Barton CPA as its new auditor and will expect the full audit of 2022 and 2023 to be completed in 30 days' time. Let me repeat that. So this is January 2024, and I gave you the prior information, and there's been plenty of representations in court and other receivers' reports, but this one is like pretty straightforward. After they hired, I keep on repeating this to kind of tell you how ridiculous this handling of their audit is. That's why I keep on repeating the sequence of events. But after they hired Fortune or retained Fortune, who they eventually had to fire because the prior auditor that prior management hired got shut down by the SEC, they then hire Barton without any explanation. And even though they apparently had a great relationship with Integrita, who could have done this job, apparently, according to them, and without any explanation why they didn't go to a big accounting firm, even though they had at that time a bunch of cash. Surprisingly, they say as of June 15th that the audit will be done within 30 days' time, and a Super 8K will be filed with the SEC upon completion. We haven't seen that because there's been no completion. We anticipate, so in addition to that, in addition to the audits that had to be redone, there also was the 2024 year. So just think about that. So we get a representation not only that the audit will be done in 30 days after Barton is hired, but we anticipate that the 2024 full year audit plus subsequent quarterly reviews will be completed before the March 31st deadline. And we're not referring to March 31st of 2026, we're referring to March 31st of 2025. Again, no explanation what happened, but obviously nothing happened. We have no completed audit. These representations of when they would be complete are complete nonsense. They obviously didn't happen. You know, I'd understand if you said 30 days and maybe 90 days or 120 days, 150 days, 180 days, you know, you'd be pissed off at some point in time, but at least there'd be some completion. Here it is, we're over 18 months and nothing. So that's, I mean, who wouldn't be concerned about that? Who wouldn't wonder why that has occurred? Especially, this is not like nobody's been putting up any resistance. It's not like they haven't been told. This is just poor, at best, poor choices, poor management, in my opinion, at best. Beyond, you know, I don't know how else you can describe the process I'm going through and not come to the conclusion that the audit process has been poorly managed. 24. 24. Note at the time of hiring, I'm just repeating this. Note at the time of the hiring of Barton CPA and earlier, the receiver had indicated the audits would be done in 30 days before the end of 2024, soon, imminently. Attached are this. At numerous hearings over the past 2 years, the receiver gave the indication and led everyone to believe that the audit would be done soon. It was almost done. It will be done imminently. But as of today, still not even a current engagement agreement with any auditor has been disclosed, let alone the required SEC filing noting such a hire. So I'm just stating it out there. Not only have we not got an audit done, we don't even have an auditor. We have, or maybe we do, and they just haven't told us about it, or maybe they do and they haven't filed the appropriate filing. Maybe they do and they just haven't got the contract done, but they certainly haven't disclosed that. And as of today, the only thing we can conclude is there's nobody as of today, and that's what my brief says. There's nobody as of today in the audit position without any explanation as of today. 25. So rather than Integrita, the receiver hired CPA Barton in 2025 after firing Fortune CPA, who was hired after Borgers was terminated by the SEC. Then perhaps the receiver and Barton CPA, got their communication mixed up, but rather than the 30-day completion date reflected in many of the receiver's reports, the person who was in charge of the audit at Barton, without any clear explanation for the miscalculation, could not complete the audit in the more than 6 months she had apparently been working on it. It has never been disclosed what, if anything, she did regarding the audit, nor why the people succeeding her could rely on her work product. But in the end, it was just wasted time and was bad management of the process. And again, to explain, so they went to Barton, the partner or person who was in charge of the audit, she was pregnant. I don't know who figured out she could complete the task or couldn't complete the task, who figured out how much time it could complete the task, but somebody made a mistake. And obviously, not enough time was allotted for her to complete the task. And when it was done, and I'm going to say it in a second, when it was done, they hired 2 more auditors from that firm who apparently had to start anew. And eventually, months later, that whole time period being more than 18 months, they quit. So I don't know what any of those people did. I don't know what the receiver was doing in managing that process. I don't know what the expert, that forensic accountant I mentioned, who's involved here somehow, I don't know what that person was doing. Why wouldn't they know about this if I had suspicions? And that's their expertise. Again, just kind of raises more questions than anything else. But the bottom line is the fact that they hired Barton, the partner didn't complete the task, just wasted more time and money. When they left, 26. As to the first auditor from Barton CPA, because of the miscalculation and mismanagement in time needed attributable to and the responsibility of the receiver, the auditor had to cease work to deliver a child prior to completing her tasks. Prior to and during this period, the maternity issue was not disclosed upfront by the receiver to shareholders, as time was of the essence for the audit too. I and others were still clamoring about what was happening to the incomplete audit. So just kind of clarify that. So we didn't know about the pregnancy. Time is passing and nothing's getting done. Everybody's bitching about the audit. And I guarantee everybody's bitching about the audit because I saw it and I was bitching about the audit too, because it didn't make sense to me why it was taking so long, especially if after Barton was brought in, especially after 30 days, etc. I and others were still clamoring about what's happening to the incomplete audit. It made no sense why the receiver could not find a competent auditor to complete a job of a company with no revenue. I actively asked the receiver's representatives to be more aggressive with and reach out to the auditor, but they refused to intervene, or words to that effect, stating that the result could be further delay. I asked many times, reach out to the auditor, what's taking so long? And the reply I would get, we don't want to reach out because that likely is that could cause further delay. Now, I don't know what delay that could have been. The best thing that could have happened is maybe those auditors would have quit earlier than they did, and perhaps we wouldn't have been delayed. And again, I never understood, made no sense to me, that why you wouldn't make inquiries specifically of the auditor, but what's going on, what's taking so long, when it's going to be finished, etc. I think that's perfectly appropriate, and in this case, it was obvious in light of the delays. It's also obvious. Well, we'll get to that point in a second. In my opinion, the passivity has cost us many months, if not longer, as to the completion of, in essence, SEC ordered audit. I think everybody has been way too passive, especially the receivership, in terms of getting the audit done. They didn't want to intervene. I don't know whose idea that was. I don't know whose suggestion it was, but obviously, as to Barton CPA, just like the choices prior to the Barton, it was the wrong choice, and it was unhelpful. 27. In or about late summer or early fall 2025, the receiver or his representatives communicated to the effect that 2 new auditors from Barton CPA had taken over the audit, but they could not rely on the work product done by the prior Barton CPA auditor and had to start over. So they basically said the prior auditor did a bunch of work, but they couldn't rely upon that. They had to start anew. Made no sense at the time. Still makes no sense. Raised it at the time. I have not heard a reasonable, coherent answer, even when the Barton CPA representative testified after they quit. Still makes no sense to me. I don't understand it. Why you'd have to start anew. Same firm. Why couldn't you move on? What did the prior person do? Did they not do any work? Was there additional monies paid? Did they bill further? Why would the auditor stay with a firm when they get a representation that's going to be done in 30 days and 6 months later the person in charge has to stop working? Doesn't make a lot of sense. Doesn't make me want to rely upon that firm, especially with the history of Fortune, Borgers, etc. Seems like you'd want to be especially careful in light of that. But here, to the contrary, just went on. They said 2 additional guys can go on, whatever. That communication Okay. That communication made no sense, and I and others gave further feedback questioning what was going on with the meandering audit process. It also concerned me that the receiver kept communicating that the audits would be completed imminently or very soon. Eventually, I saw the estimate offered by Barton CPA, approximately $165,000 for prior audits and another approximately $65,000 for the current audit, versus what had been paid, approximately $55,000, and I was perplexed. I didn't understand how someone who had been paid about 25% of their estimate could possibly be almost done. Why wouldn't the receiver have questioned this earlier? Why did the receiver keep expressing words that led everyone to believe for nearly 2 years that the audit would be completed imminently when the payment history alone would suggest otherwise? My point here, estimates $225,000. They've been paid $55,000. Even if they said they're almost done, how would that make any sense? Wouldn't that make you kind of concerned if someone gave you an estimate 4 times more than they've been paid and they said they were almost done? I mean, you'd at least ask a question. How could you have done that? Did you, how were you able to do it in such an efficient fashion? It seems like see no evil, hear no evil, but it certainly seems like someone in that position should have been put on notice of concerns based upon the expenditures that were made. 28. We're almost at the end. I also did not understand, and it appeared imprudent, that in the touchy issue of an audit of a company that the receiver maintains was virtually looted, where the SEC terminated the first auditor and the receiver fired the second imprudently retained auditor, that instead of Barton CPA or Integrita, the receiver did not hire one of the big accounting firms to get the job done. That it would at least have been a defensible position and would have quelled shareholder dissatisfaction. 29. Eventually, probably starting in later 2025, the court, in my opinion, sensing discontent from shareholders, especially as to the incomplete audit, set would have become regular status conferences checking upon the status of the audit. During this time, because it was obvious something was wrong, I called for the testimony of the Barton CPA, but the receiver's counsel, being generous, did not support that demand. Approximately 90 to 120 days later, if Barton CPA unilaterally quit the audit without completion, the court held a hearing where both Barton CPA and the receiver both testified. The reason for the Barton CPA 2026 departure was not clear to me even during that hearing, but it was during these hearings, March, April 26 or so, that the receiver brought up the Integrita name for the first time. 30. At first, this would be about March, April 2026. The receiver suggested 3 names, but immediately focused on Integrita of Boca Raton as his top choice. He again stated he had been a long-term and excellent relationship with them. They could get it all done within 120 days, including the current audit. It also came out during the questioning that GTI had less than $10,000 in cash. However, the receiver indicated he could raise the funds needed to complete the audit, or words to that effect, I would say. 31. There was a subsequent status hearing about 90 days ago or so, at which the selection of the Boca firm recommended by the receiver was affirmed. As of today's date, contradictory to the quality of the relationship represented by the receiver with Integrita, and consistent with an absence of even an engagement agreement, the receiver has yet to announce that a formal contract has been entered into between the parties. This continues what at best can be said is the inept handling of this matter. At the very last hearing, the receiver did not even address why a promised engagement agreement, just like the completion of the audit, was still lacking. 32. To summarize, and despite constant direction and concerns expressed by me and others over the past 2 years that were usually correct but ignored, the receivership has completely mishandled the audit process. 1. Kept prior management's chosen auditor. 2. Had to fire prior management's auditor they elected to retain months later. 3. At the time, chose not to select an auditor it now recommends and has been using as of that time. 4. without any clear rationale, chose an auditor, Barton CPA, who apparently didn't understand the assignment or length of assignment, so wasn't able to complete it. 5, stayed with Barton CPA months later after the receivers told 2 additional auditors were needed. 6, again in 2025, after having Barton CPA's first auditor stop and faced with 2 new auditors who had to start over, why not choose Integrita or a big accounting firm that could complete the job? 7, Barton CPA's 2 new auditors work for months and then unilaterally quit. 8, receiver still ignores big accounting firm and talks up and approaches Integrita. 9, months later, and despite talking up Integrita as of July 13, 2026 at 9:16 a.m., I'm not aware of any signed engagement agreement with Integrita or any other auditing firm. 33, and the home stretch. In light of the September 24th order of the court and the inept performance regarding the audit management and judgment, the receiver seems incapable of properly handling the Gtii audit and perhaps other obligations. As suggested by me previously, the court should appoint a 3-person shareholder group, including myself, to oversee the receiver's activities as to the audit and as to any additive transactional discussions. It is a fair question to ask whether the current receiver adds anything of value to shareholders, and is he necessary? 34, last page. As to the needed additive entity transaction, the receiver seemingly entered into a deal with AIversity, then indicated for various reasons it was not doable or a good deal, but has not clearly advised the court that they are moving on, or as far as I can tell, not opened up a new spot for another deal. Apparently, there have not been any discussions between AIversity parties for many months. I've heard information that there may be other parties who approach the receiver about a deal, but like the AIversity transaction, that those parties do not believe the receiver is being welcoming or helpful. It also seems that although everyone, including the receiver, knows that without an additional additive transaction, Gtii will never be able to trade again and will fold, that the receiver does not appear to be acting with any sense of urgency in getting a deal done. In light of the way the receiver has mishandled the audit process, he should not be trusted to unilaterally manage the transactional part either. 35, finally, and what makes what has occurred in the receivership even more concerning is that the receiver maintains he's had the use and advice of an expert forensic accountant during the process. If shareholders like me were correctly raising material concerns about the conduct of the auditors, why would an expert forensic accountant, who apparently someone is paying for, not see or feel and prevent the same shenanigans that were going on? Worse, if the forensic accountant did confirm the concerns expressed by me and other shareholders to the receiver, why did the receiver not act on that device? I declare under penalty of perjury, etc., and that's my filing. So again, my interests in that document were to kind of lay it out for the court, express concerns about the interest of shareholders, specify and kind of just go through the history of the audit and the audit handling, and reference the inadequacy, I think, and lack of transparency with regard to any transactions that are pending or need to be pending or could be pending, because we need both. We need the completion of the audit and we need an additive transaction, because just the audit alone ain't going to do diddly, but it's an absolute requirement. It's an absolute requirement that I've mentioned since day one. And here we are, day, day 700 and blank, and no audit. No excuse, really, no excuse for not having it. Inexcusable, not doing their job. Just my opinion of all. So that's the summary, not really a summary. Next hearing is August 6th and then one on August 13th. I presume, my guess is that the Receivers Council will be filing something dealing with the next hearing. We'll probably be filing a reply supporting the settlement with Benintendi, and we'll try to, I presume, either in person or in a filing, we'll try to probably paint the receiver in a different route. We'll focus on all the money that he's brought in and all the shares he's brought in, and we'll try to stay away from value to shareholders, the audit, why no transaction has been done. That's what I would expect. Kind of like, look over here, don't look at the audit. I guess they could talk about the audit and they could place the blame on everybody else. But again, I don't understand why, especially with a forensic accountant, why you wouldn't know this if guys like me had a different sense and didn't have access to all the information. It would seem like, to me, someone who had access to all the information, should be a no-brainer that you would know if people in your own trade were not doing what they were supposed to. And obviously they haven't, because we don't have a final work product. We don't have any work product. Doesn't make sense, again, why they didn't choose a big accounting firm, especially when they had the money. And it doesn't make sense to me why you would choose Barton over Antigrita. Doesn't make sense why you would stay with Fortune. Again, whole series of missteps, I believe. Anyway, next hearings, August 6th and 13th. I expect there'll be filings in the meantime. I know there are other parties that have interest in this, so we'll see where that goes. And that's it. So to all you out there who stayed here for the entire, whatever this is, like an hour and a half, I appreciate it. If you have questions, if you have differing opinions, please comment, post on X, whatever. Otherwise, I will chat with you next when I have some additional information, when there's some additional filings. Obviously, before the next hearings, I will obviously keep you informed of any next hearings and any new information that comes out. And that's about it. So to all you out there, have a great day, be well, take care, and we shall see you soon